Hello, and welcome to this edition of NLS Now Live. I am Ray Gherkin with Nevada Legal Services, and I am joined by David Olshan. Hello, David.
Hello.
And we are back in 2020 to give you live presentations on a variety of topics that we deal with. Today, we're going to be talking about the status of evictions and garnishment. So just as a reminder, this information is for educational purposes only. We are not creating an attorney-client relationship. And if you would like legal advice, please contact an attorney. That attorney obviously can be Nevada Legal Services, and we'll have contact information for you on our last page. Some resources that we're going to be talking about today include Chapter 40, the No Surprises Act, and exemptions to the garnishment statute. So with evictions right now, AB 486 is still active to protect tenants through June 2023. And remember, this applies to all eviction notices except nuisance notices. And it is designed to expedite rent assistance and hold landlords responsible for refusing rental assistance. So again, the primary things you need to do to protect yourself if you have not been able to pay rent due to the coronavirus epidemic, you can apply for rental assistance. It has to be government rental assistance. But if you apply for rental assistance and you're responding to all requests for information and checking your status regularly, you can raise that as a defense to an eviction action. And again, any eviction action basically except a nuisance. I do believe that's pretty much standard on most. We're not seeing many problems with this across the state. Most courts have adopted AB 46. Some courts may still struggle with whether 30-day no cause notices apply. But for the most part, this is an effective defense if you have submitted your rental assistance application.
And Ray, what we've seen from advocates is that if you owe rent and the landlord tries to be sneaky and not give you a 7-day pay rent or quit, the landlord may give you a 30-day. So whether it's a 5-day lease violation, a 30-day no cause, if you owe rent, AB 486 should be a defense if you're applying for rent assistance.
Correct. And if you have any trouble with that, obviously, feel free to contact us and we can see what might be possible and whether or not we're able to assist. Please do just remember, though, even if you apply for rental assistance, if you get an eviction notice, you must respond to it. Absolutely have to do something. Do not ignore it. These protections are not automatic. You do have to assert them in a defense in court.
Right. That's important. You might think you're protected. I can just sit on my butt and not do anything. No, you need to file an affidavit. You need to present that to the court, because if you don't, the landlord will go in and you'll be evicted without any hearing, without further, well, you'll get a 24-hour notice, but it'll probably be too late.
Right. And once you get that 24-hour notice, there's very little that can be done. And it all has to be done so fast, you might run out of time.
Hey, is it still a 24-hour notice, by the way?
I believe so.
All right. No, it can't be within 24 hours, but 24 hours and 1 second. Yeah, right.
All right. So because you have to respond in order to avail yourself of the protection under AB 46, we are going to talk a little bit about how the eviction process works. So the main thing you want to do is you have to pay attention to filing deadlines. Like we said, in order to raise any defense, including an AB 486 defense, you have to file a tenant's affidavit before the time of the eviction notice expires. For a 7-day pay rent or quit notice, please understand the 7 days is our judicial days, and that does not include weekends or court holidays. You do have to file an affidavit, as we've said, with the court to contest the eviction. There are self-help forms on our website, and many courts have self-help forms. So you can have a form to help you in that process. And again, you want to put the pending rental assistance as a defense on your affidavit. you do need to spell out what your defense is on your affidavit, and make sure you're letting the judge know that there is a reason not to evict you. Now, if you file an affidavit, you will get a hearing, or I guess I should say, you should, under the law, get a hearing. If you don't, please contact us. But once that affidavit is filed, you will have an option to tell your story to the judge in court. It is always advisable, though, to make sure you raise those legal defenses in your affidavit so that if something goes sideways in the hearing, you can always fall back on what you filed. And that's a lot of what courts and judges look at, is what's. Again, as we said, AB 486 should still apply even if you get a 30-day no cause or 5-day lease violation. If your landlord decides, they know that the rent notice will be a struggle, they might decide to just give you a different notice. You still have to respond to these notices in order to raise your defense. The process is just slightly different. If you get a 30-day notice or a 5-day notice, just remember the 30 days is consecutive. That's basically calendar days. The 5 days is not. 5 days is judicial days, like the 7-day. The difference in these notices is these notices lay out the reasons why you should be evicted. But in order to actually go through the eviction process, once you don't move out, your landlord has to issue you a second notice called a 5-day unlawful detainer notice. That has to be issued in order for the landlord to invoke the summary eviction process to evict. That's the notice that you need to respond to in court. And again, your pending rental assistance is a defense if your rent is owed. If you because of the coronavirus and you filed an application for rental assistance with a government agency, even if it's not a rent eviction notice, as long as it's not a nuisance notice, you should be good raising this defense. But again, you have to file that tenant's affidavit once you get the unlawful detainer notice in order to explain that defense to them. And one of the things we probably should say is always make sure before your hearing, you have all of your information ready to go. When you filed, your current application status, the last time you asked for a status update, any issues that you're having, if the landlord's refusing to participate in the process, you need to have all of that information before you go to your hearing so that you can explain to the judge what's going on, because you do have to show that you're actively pursuing.
Right. No, it's important. I think there's sort of a feeling that some people are applying for rent assistance just to have an excuse. So you want to differentiate yourself from somebody who just files the rent assistance application and just leaves it. You do want to pursue it. You do want to check on it, and bringing that evidence to the judge is going to help you to show that you're making a good faith effort to try to get that rent assistance.
All right, but that wraps up our quick update in the status of AB 486 with evictions. I do want to just mention that do continue to apply for rental assistance. I know there might be some issues with people who have received rental assistance in the past. Possibly, you might have an issue applying in the future, but that is no reason not to apply and see what money is out there, because I know that there's still rental assistance money out there. And you do need to submit your application in order to apply. Again, just remember, please, if you have a question, please post that in the chat. But we are going to move on now to garnishment and debt collection. And one of the big changes in the world of consumer law this year was the No Surprises Act. I know a lot of people struggle, and it was a big topic with coronavirus, on getting surprise medical bills, mostly when you call for emergency services and you're taken to a hospital or receive services from a doctor that is not in your insurance network. So the No Surprises Act was developed to limit that. It does prevent balance billing from out-of-network providers in most emergency and some non-emergency services. And what that means is, if you receive services from an out-of-network provider, when you're at the hospital and you have not necessarily any control over who's providing you the medical care, most of the times your insurance would say if it was an out-of-network provider, you are responsible to make up the difference. That is no longer applicable in a lot of cases when you receive services. Your insurance provider has to charge you the in-network and not out-of-network costs for that service. If you do not have insurance, it also allows you to get a good faith estimate before you receive services, and you can dispute any differences between the actual services charged and your good faith estimate. There's also a lot of, this is obviously a larger bill than this. We're just hitting the highlights. But there are also some dispute provisions that now require some negotiation and arbitration between insurance providers and medical providers to kind of remove the patient from that process. But again, the biggest thing for consumers is that if you go get services from an out-of-network provider that you really didn't have any ability to choose, you should not have to pay that out of. And then it doesn't apply to a lot of ground emergency services. In some cases, when we're talking ambulances, it does apply to air services. So just be aware that ambulances are treated differently.
I don't want to be too cynical, but the takeaway is there's no surprises that are contained in this statute, but
right.
There's still surprises.
Right. That is true. But if you do get a medical bill and it is charging you for balance billing for out-of-network providers, do look into this because you might have. All right. As we're talking about, you might get medical bills that you cannot pay. If your creditor, including the doctor, the hospital, wants to force you to pay, they have to sue you and get a judgment. But we're going to talk about, the fact that a lot of your income can be garnished.
Let me also say a couple of words. Like some people may be judgment proof or collection proof. Some people may say, well, what's the difference? Well, the difference is nothing really. It's just lawyers trying to be smarter than everyone else. Collection proof and judgment proof pretty much mean the same thing. Your money, even though it's exempt, can be collected by a creditor. And what you need to do, and what we're trying to emphasize here, is like with a 7-day pay rent or quit, you have to go to court. You have to contest the garnishment.
Right. And as I said, you will get sued. So I know there might be a lot of threats and a lot of debt collection before this happens. But in order for them to actually force you to pay, you have to be sued. And your creditor has to receive a judgment against you. You can file an answer to contest the collection action, but if you don't have a defense, it will be difficult.
It'll be difficult, and it also will add to the cost of the lawsuit. So, you want to be careful, because if you do file an answer, that means the attorney for the creditor has to file a motion for summary judgment or judgment on the pleadings. That's more money that the attorney will charge the creditor and ultimately be added to the judgment. So yes, you could be exempt. It may not matter, but you want to be careful, because if you do answer a complaint, it may add to the costs and it may make it more difficult later to pay it off.
But just remember, you might have a defense.
Sure.
And so there may be avenues to answer. We've just talked about the No Surprises Act. There might be other defenses that you might have. So you are able to contest this in court, but please, consider your options and the likelihood of success. But if you do get a judgment against you, whether you answered or not, the creditor will seek a writ of garnishment or possibly, that's one avenue the creditor has to collect. This has to be served on you, although, if the creditor gets a default judgment, it might not, especially if you've moved and, there might be issues with service involved. But, eventually you will get notice that something has happened, because they will start garnishing more. But once the writ of garnishment is issued and served, the funds are frozen because you have the ability to contest the garnishment. You have 10 days to file a claim of exemption with the court, and that lays out how your income is exempt from collection. And it could be because you have Social Security benefits, and most regular judgments are not able to attach Social Security benefits. It could be that you don't make enough to get garnished. There are a lot of reasons why you might be exempt from collection of the debt. but you do have to file that claim of exemption with the court. Otherwise, the money will go to the creditor after the 10 days expire. But if you file a claim of exemption, if the creditor does not object, the money will be returned to you. But be aware that that might make time. Most places use national processing services, and by the time the money gets back to your payroll to get back to you, it could be a while.
Right, right. Another thing that we're not talking about is government offset. So if there's a tax bill that you owe, if there's child support, the government may just be offsetting your money without getting this judgment, without going through this sort of formal court process. So you pretty much have to sort of figure out what this money is going to. If it's going to a creditor through a lawsuit, that's what we're talking about here. We're not talking about an IRS sort of offset of your tax return or your Social Security benefits or anything like that.
As I said, you will get notice of the garnishment, because you have to get notice before the money is taken, and then you'll get notice because your paycheck is confirmed. You can file a claim of exemption with every garnishment. You will also get accounting of any payments made and new garnishment documents every 6 months. The creditor may renew the judgment every 6 years, and the bank obviously, David said, should not freeze your Social Security.
Also, debts over 6 years old, they're probably time barred, meaning the statute of limitations has run. But when you get a judgment, that judgment can stay with you if it's renewed for your entire lifetime. So don't think because the judgment is more than 6 years old, it's barred by the statute of limitations. It's not, because they have a judgment and they can renew it.
David, do you want to go through the income exemption?
Oh, great. Yeah, give me the hard stuff. All right. So basically, if your income is below $362.50, minimum wage times 50, federal minimum wage times 50, it's all exempt from any type of garnishment. And when you're between $362.50 and $770, I guess, it's just all right. So let's keep it simple. $362.50, it's all exempt. If you're between $362.50 and $441, the creditor will subtract out the $362.50 and be entitled to the rest. So let's say your income is $430, then $430 minus $362, that's what the creditor can take. And that's in NLS Chapter 31. It's right there. They can't take 18%. They can't take 25%. They have to subtract $362.50 out of your income, and that's what they get. If your income is between $770 and $442, then the creditor can only take 18%, and that is your average weekly wage. It's easy now because we're in January, but it's your average weekly wage for the year. If it's less than $770, they have to take 18%. If it's more than $770, they can take 25%. Jeez. Okay. I don't like this, obviously, because I'm making comments. It was changed a while ago, and it was changed because some advocates thought, saving $25 or whatever would be worth this added complicated math. And from my estimation, it's not. It just makes things much more complicated. And if you're at the end of the year, it's hard to figure out what your weekly wage is. If you've changed jobs or if you have been off for some period of time, the average weekly wage is going to be difficult to calculate. Does that make sense, Ray?
Yes.
Okay, good.
I mean, it's just, it's numbers. You might have to sit down and actually take your paycheck and go through it. But that's unfortunately what you have to do. And
Right,
yes, it is more difficult, but
you can take a sort of easy sort of thumbnail sketch. If you make $1,000 a week, but $1,000 a week, they can take 25%. So you're going to get $750. The creditor is going to get $250 until the debt's paid off.
And then, obviously there's other income that's just totally exempt, the government benefits. So
Oh, right. We're just talking about wages, Social Security, child support, unemployment benefits, pensions. Those are all exempt. And so you should be able to keep 100% of that, and the creditor should get nothing.
And then the only caveat I will say for child support, I guess for Social Security benefits is child support will come out. Just keep that in.
Sorry, Ray, you broke up. Child support will what?
Come out of your Social Security benefits. So just, child support is treated differently.
Right.
Just be aware.
Yeah. SSDI, disability, what is it? 25% can be taken for child support. SSI, nothing.
I think it's up to 50.
Whatever it is, they can take it out of it, but they can't take money out of SSI. So go crazy if you get.
Obviously, we're talking about Social Security is not a lot of.
All right, so these are some of the exemptions under Nevada law, and the statute is NRS 21.090. A homestead, you have a homestead exemption in Nevada, $605,000 in equity. So that's the amount that the value of the home minus the mortgage is your equity. And so if you have any amount over $605,000, then the creditor may be able to take it by selling your home and skimming off the unexempt equity. One car is $15,000 in equity. With car values so high, maybe you're going to be higher than that. But yeah, $15,000 in a car, any amount if it's a car that's adapted for the disabled. Household goods, your furniture, your clothing, your dishes, your electronics, $12,000 is the exemption. And then let's say you have $12,100 in household goods, there's a wild card exemption that you can use. Usually we're using this for bank accounts. So if you have $5,000 in the bank, your wild card exemption will exempt that and you can keep it.
And I know, David, you mentioned, what judgment proof means. And all that means is you have to file the form of exemption. Just keep that in mind. You do have to assert that your income is exempt in order to technically be judged.
If you're living or you're getting just Social Security retirement every month and you're living in an apartment and don't have a lot of property, you're judgment proof. Your income and your assets are exempt. And it applies when you're considering filing for bankruptcy. Well, maybe you don't have to because basically all your stuff is exempt and you can keep it without the creditor reaching it.
And that's, a lot of times what information we give people when they're trying to decide whether or not to file bankruptcy is, you look at what your income is, look at what your assets are. And if you're exempt, there might not be a reason to file bankruptcy.
And that is that.
Concludes our presentation today. So there's one question. I would just like to say that just remember that the time frame on a pay run or quit notice is 7 judicial days. If there are any other questions, please feel free to add them in the chat for the next, minute while we're on. But for more information, you could go to our website, nevadalegalservices.org, or contact any of our offices. Please call or go online. We are currently closed because of coronavirus to the public. Our offices are closed. We are still all working. We will answer our phones. We will review our online intakes. So please feel free to reach out to us. Just do it. All right, David, any final thoughts?
Again, when you get an eviction notice or you get a garnishment, please address it. Please act quickly to keep your home and keep your money, because you have time limits, 10 days to file a claim of exemption and 7 days to address a pay rent or quit notice.
All right. Thank you.
Ricochet rabbit. Sorry.
Yeah. Thank you all for joining us today. And that concludes our live seminar. We will be back next month, and we'll be advertising that beforehand, and we'll see you next.